Hi guys, welcome to the Trucking History Channel. You know, we've got the 90th anniversary of signing of the Motor Carrier Act of 1935 coming up. 90 years. 90 years ago, the Interstate Commerce Commission began regulating the trucking industry. Now, it had already been regulating railroads for decades, but regulating the trucking industry, that was a whole new thing. How did it get that way? Well, cars evolved into light trucks in the 1910s, and people discovered they could haul things in a makeshift truck from the train depots to the local stores in cities and towns. And then around the 1920s, trucks really evolved into their own separate vehicle. Although they were still based on car chassis, different bodies were starting to be used. You had your stake bodies, you had your box van type bodies. And although roads were still simple, not yet fully developed, trucks were able to go a little bit further. Although at slow speeds, because you know the trucks in that day were only 20 miles an hour or less that they could go. But traveling by truck and hauling freight between cities and cities within a state became more commonplace. So in the late 1920s, a lot of the states were starting to regulate the trucking industry within the boundaries of their own state. Interstate freight lines were, well, they were beginning to happen, but cross country, no. Between one or two states, yes. But states started to also issue permits for interstate freight. They had already started doing it on intrastate, within the state boundaries. But at times, trucking companies were wanting to enter the state in interstate freight. So the states got involved with that. Railroads were up in arms. Oh, we can't let this newfangled trucking industry take away our revenues and freight. So they put up a big fight. There was years being spent talking about regulating the newfangled truck. States talked about it. The government talked about it. Trucking companies talked about it. They didn't know what to think if the government got involved with regulating. Well, there were some good things that came out of that. There were a lot of fly-by-night operators. Buy a truck, haul freight. They didn't care about rates. They only wanted to charge what they could get. Safety, as long as it had a flashlight or a headlight to see, they could drive at night, or so they thought. But anyway, things evolved. And then the United States government took a real hard look at it, so that in the early 1930s, they really were serious about regulating trucks. There was a lot of talk about it, a lot of discussion. So that in 1935, they finally did it. They passed a law, the Motor Carrier Act of 1935, regulated everybody. Interstate trucks, whether you were in general freight, which they called a common carrier, or by that time, trucking lines and individuals were hauling for certain businesses. So there was a stipulation for getting a contract carrier permit. Then if you wanted to arrange for freight from point A to point B, you were a broker. You would get a license for that. Okay, things went well. Everybody knew the law was passed, and they were given until February of 1936 to submit an application to continue as a truck line or to start a new one. Now, at first, the Interstate Commerce Commission wanted to only deal with what they called the grandfather clause. If you were already in business and you could prove that you were consistently offering a service between selected points that you would want to continue, then you would put that in your application. There'd be a hearing to make sure that, the opposition, the railroads, and whoever else could say, nah, we don't need to give them a permit. But chances are, if you were already in business, already doing it, and could prove that you were providing consistent service, bringing in companies that supported your business and could tell you, yeah, you're doing a good job, chances are you would get a grandfather clause provision and get a common carrier certificate or contract carrier permit. There were a lot of people who thought they were under the grandfather clause, but actually it was proven that they weren't. They didn't get what they wanted. It was proven that they weren't in business. But anyway, things went good. All right, it took several years to get over the 100,000 applications that had flooded the ICC office in Washington, D.C. So it wasn't until the very late 1930s, early 1940s that they could approach the applications for new companies. Now, if you were a new company wanting to serve an area that was already being served by somebody else, you had to prove your motor line was necessary. Maybe if you could show the need why you were necessary over the same route, chances are you get it. You still have to go through the hearing and prove it. Not everybody got that, but the ones that did, they prospered. Okay. The thing about the ICC and regulating the trucking industry, they knew that there could only be so many truck lines operating from point A to point B. There were only so many that could operate from Philadelphia to New York. Everybody had an equal playing field. It was up to you to get more business and prosper. ICC wasn't going to do it. So once they got to the point where they felt more applications and more certificates, more companies would hurt those already in the business, they said, no, it's not needed. That's why they called the operating certificates a certificate of operating necessity and convenience. It had to be necessary and it had to be convenient. If you couldn't show it was convenient to the shipping public that your service would be used, you wouldn't get it. If you couldn't show that it was necessary, you wouldn't get it. You prove those two things right there, you were shooed in. You had to prove it. You had to really work hard. You had to hire a lawyer. Now, there were lawyers at that time who were specialists in working with the ICC, whether you were applying or whether you were opposing an application. There were lawyers you could hire to do just that. And in an earlier video, I talked about the many applicants in Seaford, Delaware that used the same lawyer. He won the first case, but everything after that he lost. So, you had to be careful. But there were lawyers involved. So that's how it got started. Okay, let's talk about some of the good things that came out of the trucking industry being regulated. Each time the holder of a certificate or a contract carrier permit that was issued by the Interstate Commerce Commission, anytime they wanted to expand their routes or grow, expand the business beyond what territory they were already in. They had to apply for the change or the expansion and get approved by the Interstate Commerce Commission. These expansions could be as little as wanting to use an alternate route. A lot of the companies initially, when they specified their routes, which is called authorized routes, a lot of those routes were on U.S. highways. As interstate highways were built, and in a lot of cases alongside or close to a United States highway, if the carrier wanted to use the interstate highway instead of the U.S. highway that's specified in their certificate, they just couldn't do it. They had to apply for permission to use that alternate route with the Interstate Commerce Commission. Now, whether it was saving distance, saving time, or perhaps avoiding going through cities and towns, didn't matter. You still had to apply for permission. Now, once you got it, you could use the interstate all you wanted to. Another reason you had to go to the Interstate Commerce Commission for permission to expand is if you wanted to add to your routes. Let's say you're a company and you were going from Charlotte to Memphis, and you wanted to expand your route to go from Memphis to, say, Little Rock, Arkansas. Well, you just couldn't do it without permission. You had to ask permission from the Interstate Commerce Commission, apply for what they called an extension of operations. And if they approved it, it would be known as a sub number to your docket. Like, for instance, docket 110875, Branch Motor Express. Let's say they were already operating to Greensboro and down to Sherrill, South Carolina, down to Florence. Let's say they wanted to go past Sherrill on US 1 and go all the way down to the other end of South Carolina. They just couldn't do it. They had to go to the ICC and say, hey, we want to continue down US 1, past Sherrill, South Carolina, and go to the state line of South Carolina where it meets up with Georgia. Branch would have had to give good reasons why and hope that they would get permission. Now, not every time you would apply, you would get permission. A lot of times the opposition would be there. Other trucking companies that were already using that route and saying, hey, it's not needed. You're going to take business away from us if you let this other company in. Another reason you had to seek ICC approval for anything is if you wanted to buy some bankrupt trucking company over here that was losing money and about to go under, and this company over here was profitable and could take it over, and their routes met at some point. The routes had to meet at some line on the routes. The two carriers had to meet. That's the only way you could do it. Well, in some cases, the ICC would give blessings immediately. Say, yeah, this is a good company, and their routes meet such and such place, so yeah, do it. But a lot of times, if you went a little bit too far in your expansion plans, the ICC would say, no. Happened a couple of times. There was a period in the 1960s when Consolidated Freightways was trying to buy everybody they could to become a nationwide carrier. Oh, they were after everybody. And each time the ICC would say, no. They finally got to be from coast to coast. But in the 60s, they were after anybody that moved. Oh, we want to buy you. We want to buy you. Another instance, when the ICC said no. In 1940, there was a plan where Transportation Incorporated out of Atlanta, Georgia, had this grand scheme of combining more than 24 trucking companies all up and down the eastern seaboard to form one company. Oh, there was a lot of companies in that list. A lot of them. Including Branch Motor Express, my favorite. I know, I pick on Branch a lot, but I can't help it. We all have our favorites, right? But in 1940, when Transportation Incorporated had this list of more than 24 carriers they wanted to combine and make a big, giant company, the IC said, no, you're not quite ready for that. Or the industry is not quite ready for that. Well, 2 years later, the list was shorter. So it was only 7 companies this time that they wanted to combine, all up and down the East Coast and into Ohio, places like that. The company that was created ended up being Associated Transport. And at that time, it was the biggest company on earth. Too big to fail? Yes. They went out. They had shoddy service at times. Oh, there's reports where a shipper would call and it'd be a week or more before their shipment would be picked up, if at all. And yes, they complained to the ICC, and the ICC investigated and found, Associated Transport, you got to do better than that, or we're going to take away your certificate. Well, what are you going to do? You got to get better, or at least attempt to show that you are. So that's how Associated Transport came into being. A massive number of 7 big carriers, and these were pretty big carriers, and they all formed to form Associated Transport, and at the time it was the biggest there was. That lasted until the 70s, and then Associated Transport went kaplunk. It wasn't the only big one too big to fail, but they were among the first. There were instances of big carriers long before Associated Transport that failed. Keishan Motor Express is one. Oh, they were big. In fact, Interstate Freight System, the one with the $sign logo, real early in their career, real early in their history, they were known as Interstate Motor Freight Corporation. They went bankrupt. And from the ashes became Interstate Freight System Incorporated. That's the one that survived. So it doesn't matter the size of the company or when. There were quite a few that did fail and didn't make it. So that's a quick little history on the 90 years since the Motor Carrier Act was put into force and signed into law in 1935. It lasted until 1980, and that's when deregulation started. But I thought it might be good to go down memory lane since we are at the point where the 1935 Act was signed into law by Roosevelt. Hope you've enjoyed this video. If you have, leave a comment. Be sure to subscribe if you haven't already. I have a goal of hitting 1,000 subscribers. I don't have a goal of when, but I do want to have 1,000 subscribers. I'd appreciate it. And if you have any ideas for future videos, leave that in the comments too. See y'all next time.